Peter thought he'd get away with introducing 3 speakers at once, but he can't. So it falls to me to introduce Chris, but before I get there, I would just like to briefly comment on the presentations we just heard, because I think that's really one of the great strengths of this organisation, is the way in which the legal and housing arms respectively cross-pollinate each other, provide understandings to each other, and address oftentimes what are fundamentally the same thing, the same issue. I think at every opportunity it needs to be said that according to Vic Health, the principal cause of death and disability in this state of women under 45 is intimate partner violence. The principal cause. Whenever I reflect upon that, I am gobsmacked. I'm gobsmacked. And you've just heard from people working very hard to try to assist women who are confronting family violence issues through the legal system. So very many of them are also seeking help through our housing arm. That makes complete sense where the major cause of homelessness among women and children in this state is intimate partner violence. In Australia, according to the Australian Institute of Health and Welfare, around 230,000 people annually seek specialist homeless services. So that's not specifically all of ARC's work, of course, within its housing arm, but we certainly have many, many, many clients who are homeless or on the brink. 230,000 people annually seek specialist homeless services. 78% of them are female. 1/3 overall, so a significantly higher proportion of women, I would suggest, but 1/3 of such people overall attribute their homelessness to domestic violence. So there's plainly a great connection between, on the one hand, the work done by the CLC in particular, perhaps in its family violence work, and the housing work that's done on the other hand. The reference to health and the socio-legal determinants of health, plainly a person who is homeless, a person who has a great many legal issues on their plate, a person confronting domestic violence, a person confronting perhaps homelessness while responsible for a child, is plainly going to have their health adversely affected, and that's a real interest of Peter and of the CLC and of ARC more broadly, and I sincerely hope that it continues to be a great interest of this organisation. It's apt, perhaps, that it's only a week today away that we celebrate the UN International Day for the Elimination of Violence Against Women. Now, the elimination of violence against women plainly has a long, long way to go. Again, let us not forget that according to Vic Health, the primary cause of death and disability among women under 45 in this community is intimate partner violence. So the work and the importance of the work that's done by the CLC side of ARC and by the housing side of ARC can hardly be overestimated. Talking of the connection between homelessness and legal remedies is a perfectly apt point at which to segue to introduce Chris, our guest speaker, but I'm not going to, because I need to again acknowledge Trevor Elliott and thank him so very sincerely for his many years on the board, and ask Trevor to come forward to accept from the board a small token of our appreciation. Join me in applauding Trevor as he comes forward. Thank you. So, to Chris Povey. Chris is a lawyer who has worked extensively in the area of housing rights and access to justice for people experiencing disadvantage. He was recently appointed the manager of the Mental Health and Disability Advocacy Program at Victoria Legal Aid. Previously, he has been the manager and principal lawyer of the PILCH Homeless Persons Legal Clinic, which was a project in which ARC had a direct involvement, and Principal Lawyer with the Tenants Union of Victoria. In 2010, Chris was awarded a Churchill Fellowship focusing on keeping vulnerable tenants housed. Please join with me as we welcome Chris.
Thanks very much for that introduction. Oh, 2 introductions, which is fantastic. I just want to acknowledge the amazing work of the Advocacy and Rights Centre. I've had a bit to do with Pete and Anna and some of the other guys here, Mim. I think perhaps you guys know, I've got no doubt that you already know the amazing work that the centre does, but really is best practice, some of the best stuff that's out there. I think this emphasis on relationships and what a good relationship looks like and different ways of cutting legal need. Loddon, ARC is renowned for that, and you should be congratulated. And it's an honour for me to speak at an event such as this, so thank you. I'm not going to be checking my Facebook, but I will be keeping an eye on time because I don't want to be boring you all rigid. This is your time, not mine, clearly. What I wanted to do tonight was just talk about some of the work that I've been involved in at Homeless Law, which is what the HPLC used to be called, the organisation formerly known as the HPLC. I'm kind of running off fumes of the old job, so apologies if I refer to that role as we. I'm just sort of making the break. And what I'm going to do is talk about a few clients that Homeless Law assisted and kind of what those cases tell us about the important work that the Tenants Advice Service is doing here in Bendigo, and why it's important that we look very closely at how we keep people on housing and the framework that surrounds that. So I'm going to start talking about this client called Maria. She had 3 kids, and she had a relationship characterised by pretty extreme domestic violence. And the interesting thing about this particular case was that when you're in public housing, you don't want to give it up. I mean, everyone who deals with clients in this situation knows what that's like. So the client didn't feel safe at home. She had an intervention order. It was breached all the time. It wasn't worth the paper it was written on. The cops were stretched very thin in her local area, so they couldn't come out and check up on breaches and those sorts of things. So she and the children started moving around. They were staying with friends and family, wearing out their welcome there, then moving to a motel. All the time, they're trying to pay off public housing rental, and they're not doing it. So they're getting further and further into arrears. But they don't want to give up their public housing because then they'll be just bounced to the back of the list and they'll never get back in. So, I mean, here I am as a lawyer going through some of the factors of this particular client in a kind of clinical way. But, I mean, if you think about living that situation, about being subjected to horrible violence and having kids who are looking to you to maintain some kind of sense of stability, it's hard to kind of imagine, really. And the client's circumstances deteriorated. Her mental health suffered. The children's behaviour was erratic and hard to manage. Children's services were involved. And another thing, as a result of the relationship, Centrelink payments were cut off from time to time. So I'll just park that case study there. Safe to say there was an issue, a tenancy issue with arrears. So all of that stuff, all of the stuff that the Family Violence Project here knows about, connecting with the tenant stuff. Another client that we dealt with was Rachel. So her personal circumstances, again, to kind of go through the checklist, she had serious substance dependence issues, she had mental health issues, and she'd spent half of her life in prison. And what I'm getting at with some of these clients is that these are things that when you see government documents, everyone's saying, oh, people leaving prison, domestic violence survivor. These are people that we should be prioritising services for. And the reality is that we're not seeing it. So talking about Rachel, substance dependence, mental health, experience in prison, and what happens? She winds up $2,000 behind in her rent. Not outrageous, but still enough to get you chucked out. And she offered $400 and a payment plan to try and get herself back on track. And I'm going to get back to her as well, because the point of this all is to say, how were these people dealt with by the system? How does our current legislative framework acknowledge all of these interconnected problems that we're experiencing? The final client I wanted to talk about was somebody that formed the basis of this Churchill research that was mentioned earlier. So John was a guy who was homeless since he was a young man. So since before he was 15, he'd been sleeping on friends' couches, he'd been staying in cars. And during that period, he developed, it's all bad news, unfortunately, sorry. He developed a serious mental health issue. He tried to kill himself a couple of times, and he also developed a severe substance dependence issue. And the interesting thing, and I think tenant advocates see this all the time, it's some of these special circumstances that get you fast-tracked into housing. So he got priority access and he was given public housing as a result of that. But then he was subjected to eviction for illegal use, and the alleged illegal use was low-level trafficking. We're not talking big boatloads of stuff. He had a plant and he was dealing to friends. Not behaviour I would absolutely endorse, clearly, but when you're dealing with people like John, you need to keep in mind the reasons for which they're being placed in housing. So to recap, we had Maria, and her circumstances involved, she had children, dependent children, she had health concerns, and an experience of serious domestic violence. We had Rachel, who had involvement with the justice system and mental health issues. And we had John, a young person who also had mental health and involvement with the justice system as well as substance use. And the question that I would ask, and I mean, obviously the tenant advocates are ruled out and some of you others are ruled out, but I mean, what impact or significance do those circumstances, those key indicators of vulnerability and risk, what impact do they have on eviction proceedings and tenancy matters? And the answer to that, I'll answer it, I'll ask a question, I'll answer it, is none. They have no impact at all. The Residential Tenancies Act seems to operate in this kind of vacuum where people aren't evicted into homelessness, that an eviction for somebody with an experience of violence with dependent children is the same as somebody who's waged and earning, and it's not the case. So I'm just going to quickly talk about the kind of framework of decisions and the way in which eviction matters are currently dealt with. So essentially the Residential Tenancy Act doesn't allow consideration of individual circumstances. It doesn't let people talk about health, about dependent family members, about experiences of homelessness. That's off the table. A good example is, the exception that proves the rule. So in arrears matters, there is a discretion. You don't have to automatically make a possession order if the ground's approved. But in that particular case, it's that financial loss can be avoided to the landlord. I think that's a really telling indication of a real gap in the Residential Tenancies Act. And another thing that you might think, oh, well, we've got the Charter. The Charter will save us. There's the protection from arbitrary interference with the home in Section 13 of the Charter. And yeah, that's right, and that stands, and that is something that would enable you to get consideration of individual circumstances. The problem with that is a decision of the Court of Appeal called Sudi, Director of Housing and Sudi, in which the Court of Appeal found effectively that the Charter is out of bounds at VCAT. And without going into jurisdictional stuff or whatever, it just means that when MIM's down there or when an advocate's down there, they're not going to start waving around an edition of the Charter and talk about Section 13 and say, look at this guy's experiences, he's going to be wind up back on the streets. It's not relevant. The only place you can raise Charter arguments now is at the Supreme Court. And for advocates across the state, at the Tenants Union, at Homeless Law, that's not all that helpful. And it's interesting and telling that since the Sudi decision, not another matter, not one housing matter has proceeded to decision at the Supreme Court. And one thing, I'm always giving it a little bit to Justice Weinberg, because he made some statements in that Sudi decision that I think are really quite telling and reflect what I think we implicitly know if we do housing work. Justice Weinberg said that human rights must not thwart the eviction process. I'm paraphrasing clearly, but I think that's an interesting thing to think about. Human rights must not thwart the eviction process. So we need to be able to evict people. Don't worry about human rights. They can't thwart it. We need to be able to evict. And he also said that tenancy matters need to be dealt with quickly, efficiently and sensibly. Well, sensibly, let's not argue about sensibly, but quickly and efficiently. And that's certainly what's happening at VCAT at the moment. Anyone could probably tell you. I think the experience here in Bendigo that there are, 30 matters on the list and you represent 2 people who are turning up. The people who turn up are doing pretty well, because the vast majority of people, in my experience, particularly in regional areas, are not going to the tribunal. Approximately 60,000 thereabouts applications are heard by the residential tenancies list every year, and about 50% of those are possession order matters. And we've heard again tonight about how a fraction of those, a very small fraction of those, are matters in which representation is a factor. And the thing is, we don't know what happens to people when they're evicted in their absence. Where do they go? I will wind up very quickly. I'm starting to rant, clearly. What we do know is that across the country there has been a 17% jump in homelessness. We've now got over 100,000 people in Australia who are homeless. There's been a 20% jump in homelessness in Victoria, New South Wales, Tasmania and the ACT. I mean, those numbers give you pause. You need to think, or maybe in such an environment, evicting people isn't brilliant. And it gets worse when you look at what's going on with housing. So 36,000 people or thereabouts wait for public housing. The Victorian Auditor General said our public housing system was on the verge of collapse, which must have been painful for the department that day. And there's a chronic shortage. Anyone knows there is a chronic shortage of affordable housing. So in this environment, I think it's a bit of a no-brainer that access to tenant advice services and SHASP and these kinds of things is of fundamental importance. Advocacy and rights are of fundamental importance to keeping people housed. I mean, I think the argument for advice and advocacy and rights support, it makes itself. But at this stage, it doesn't seem that there's a great deal of government acceptance of the need for this kind of stuff. The research that I did without going into it looked at the fact that really we have got some of the worst tenure security in the developed world. I mean, it's easier to evict people here, in Australia or in Victoria in particular than many places. We need to turn that around. We need to make eviction a last resort. You hear it all the time, but really it's very easy to evict people, particularly when you're not able to talk about individual circumstances, when you're not able to talk about health and homelessness and violence and all these other things that make eviction devastating for the clients that we see and assist. So I think eviction is a red flag. It's a key intervention point that we need to be making, a point at which we can get in the services. And Bendigo, you guys are doing it already, but we need to get recognition for the importance of that. It's a key intervention. We need to be making better decision. And at the point of eviction, we need to be able to put on the table what we're dealing with. Who is the person that we're about to turf into this affordable housing crisis? So thank you again for having me to speak, and great work. I congratulate you all.
Thanks, Chris. That just really pulled together so many things and themes we've been talking of this evening about the connections between homelessness and law, and about the work that's in front of us. There's obviously, one might think, occasion for consideration as to how far the Residential Tenancies Act ought to proceed on the basis that we're just talking about contractual rights between presumably remotely equal bargaining parties, which so demonstrably we're not. If the Legislative Assembly should ever reconvene, perhaps that's something which they might consider addressing, subject, of course, to Mr Shaw's thoughts on the matter. This brings to a conclusion the formal part of tonight's events. I would encourage all of you, though, to stick around for a cup of tea, a coffee, a biscuit, a cake and a chat. I'm particularly pleased, as I earlier said, to see Alex McTeer here, to see Trevor Elliott, to see others from the board. Barry is here, and Jane, our departing EO, and I see also other people who have contributed immensely to this organisation floating about, past and present staff. So please do stick around for a bit and have a chat, and thank you so very much for joining with us today at the ARC report to the community. Thank you. And to thank Chris for his cogent and inspiring words, and to apologise for kicking his glass of water onto his papers and his bag, please applaud him as he comes forward to collect his lovely gift.